The purpose of this lecture is to reinforce the concepts of stare decisis and precedent that we talked about last week. Okay. There will be no chapter to read in the book this week. The reason is I know these concepts are difficult for students to grasp, and so I think we need to spend another week on them so you really understand kind of how they work in your mind. Okay, why is that important? Is because if a case is or isn't controlling or binding on a court, we're wasting our time looking at it if there is some binding authority that the court must follow. Okay, so I'm not going to go over necessarily pages 1 and 2 of this particular document that I want you to pull up. Okay, the document you need to pull up is the stare decisis exercise, and it should be found right where you clicked on this link to open up this video. I'm just going to basically summarize the first couple pages. The particular issue at hand is what we call browse wrap agreements. Those are agreements that basically when you download software, things like that on the internet, that you click on I accept, and of course you never read that, and you go ahead and download the software, right? Nobody ever reads that stuff. It's too long and boring. But the issue is, in this particular case, we're going to be in New Mexico State Court. Okay, this is a fictional issue brought before the New Mexico State Court. Okay, so we're going to assume we're in New Mexico. And there are two cases that other courts have decided, and we're going to just try to figure out if the New Mexico court must follow those decisions. For purposes of this exercise, we're going to assume that this is what we call a case of first impression, which means it's a new issue that has to be dealt with by the state courts in New Mexico, and generally that means that the court's free to determine the outcome of the case on its own. Okay. So you can read the facts on the first couple pages yourself. They're fairly self-explanatory. What I want to get into is how the court would determine whether they need to follow these two decisions, which are pulsar or spread. Okay, so let's go to page 3. At the bottom of the page, there's a box. Okay, if the judge in the case was handling this might be the legal analysis he would go through. The first question he would ask is a browse wrap agreement binding upon the person downloading the software? Okay, since this issue is brought in New Mexico State Trial Court, remember the court will look for what we call controlling authority. Okay, controlling authority would be precedent which he would be bound to follow under the doctrine of stare decisis. So he'd ask, hey, does the New Mexico Supreme Court, have they ruled on this same issue? Because if they have, end of discussion. Okay, if New Mexico State Supreme Court has ruled on the issue, a New Mexico State Trial Court must follow that decision. Okay, now if there's no controlling authority, the court will see if the issue has been addressed by courts of other states and jurisdictions. Okay. Also, the trial court is going to look and see if this particular issue, browse wrap agreements, have been dealt with. If they have not, then they would look at similar cases, okay, and they talk about on page 1 the old shrink wrap agreements. And another one, I don't know which one, shrink wraps, and so they look at other cases that dealt with very similar issues to guide their decision. In this exercise, we're going to assume that no court in America has dealt with the browse wrap agreement issue and whether it's binding on the people downloading the software. Now I am on page 5 of the handout, and in the first box at the top of the page, the first New Mexico State Trial Court has weighed the issues and the facts, and they've decided that brown wrap agreements are binding on the parties downloading the software. Okay. Now, let's say the case comes up again in another New Mexico trial state trial court. So let's say the first one was in Santa Fe, and now we've got a trial court in I don't know, Albuquerque that has to decide the exact same issue. Okay, so now the question is that state court decision from Santa Fe trial court binding on the trial judge in Albuquerque? The answer is no, because if you remember from my lecture last week, trial courts are like the privates in the court system, and one private doesn't have to listen to what another private says. They're not higher up in the chain of command. So the judge in Albuquerque is free to make up his own decision. He is not bound by the trial court's decision in Santa Fe. So the second trial court decides that they are not binding, okay, and that's at the top of page 6. Okay, now we've got a third case deciding this issue in New Mexico, and that is a federal court. Okay, we haven't gotten into the court structure yet, but just understand this. There are the federal courts and there are state courts, and they're completely different systems. And in this case, we're dealing with an issue of New Mexico state law. So what normally would happen is the federal court will apply, if it's a state law issue like contract law, normally the federal court will look to the state law and follow the state law and the state law decisions on that particular issue because he's in New Mexico. Okay. Now this is the problem. One court in Santa Fe says it's binding. Another court in Albuquerque says it's not binding. So there's no what we would call controlling authority that the federal judge could defer to in deciding this particular issue. And the judge now decides that browse wrap agreements are binding on the downloaders of the software. Okay, so we've got a federal court that says binding, a state court that says binding, and a state court that says not binding. Let's go on to page 8 of the handout. Now we're going to assume that the party in the first trial court decided to appeal the decision because he thinks the judge got it wrong. And that's what you do when you think a judge got the law wrong. So he appeals to the New Mexico Appellate Court. The New Mexico State Court of Appeals, for whatever reason, agreed with the trial judge in trial court number 1 and upheld this decision and held that the browse wrap agreements are binding. So, assuming that there's only one court of appeals in New Mexico, which I don't know if it's the case or not, but let's assume that it is. From now on, browse wrap agreements in the state court system in New Mexico are binding. Okay, now as a little nuance, it only applies to future cases. Okay, so does that mean that that decision in New Mexico State Trial Court 2 is now overturned? Well, the answer is no, because the appellate court of New Mexico decided that the agreements are binding after the trial court decided they were not binding in trial court number 2. I know that's a little confusing, but just understand this. If a case happened before the appellate court's rule on the matter, generally, unless it's a criminal matter involving constitutional law, I don't want to get into that, generally that decision, even though it's different than the appellate court, because it was decided earlier, is still binding, but only on the parties to that particular case. So, trial court number 2's decision that the browse wrap agreement is not binding is still okay, but it won't apply to future cases. It will only apply to the particular parties in that case. Now I'm on page 9. So let's assume that the person that lost in the New Mexico appellate court decided to appeal to the New Mexico Supreme Court. And the New Mexico Supreme Court turns around and says, guess what? In New Mexico, browse wrap agreements are not binding on the person downloading the software. So what they're doing is they're reversing the appellate court decision. They said that the appellate court got it wrong, and the state trial court got it wrong, state trial court number 1. And they're kind of siding with state trial court number 2 in saying they're not binding. So in this particular case, the New Mexico Supreme Court doesn't have to look to the federal court decision. You look there, New Mexico Federal District Court 1, in determining the case, because the state Supreme Court is the ultimate authority on state law, and this involves state contract law. So they do not have to follow a district court. They're in a different chain of command, okay? The federal district court is in the Navy, and the New Mexico Supreme Court is the general of the Army, okay? So they're in different branches, to use the analogy from last week's lecture. Okay, now, so if the New Mexico Supreme Court decides that the browse wrap agreements are not binding on the downloaders of the software, that settles the issue in New Mexico. Every trial court and appellate court in New Mexico must respect the decision of the New Mexico Supreme Court on state law. Okay, so now the issue is settled in the New Mexico State trial court system. Now we have to figure out what's going on in the federal system, what's going on in the Navy. Okay, remember in the first New Mexico Federal District Court, which are the trial courts in the federal system, there was a decision that the browse wrap agreements are binding. Now, does a different federal court in New Mexico have to follow the decision of the original federal court decision that the agreements are binding? If you look at the top of page 11, the answer is no. Because remember, these are both trial courts in the federal system in New Mexico, and one trial court's decision, since they're both privates in the Army, is not bound by another trial court decision on that issue. A different issue is now that we have the New Mexico Supreme Court deciding the issue that browse wrap agreements are not binding on the citizens in New Mexico, must the federal court in the second case follow the New Mexico Supreme Court's decision in that regard? The answer is yes, because once the state Supreme Court of New Mexico has spoken on an issue of state contract law, the federal courts will defer to that decision and consider it binding on them. So in the New Mexico Federal District Trial Court number 2, they will look to the state Supreme Court of New Mexico and say the agreement is not binding and defer to their expertise in the area of New Mexico state contract law. So now we have a federal court 1 that said it's binding, and federal court 2 following the New Mexico Supreme Court in saying that it is not binding. Now, if you look at the bottom of page 12, the original loser in Federal District Court number 1 decides to appeal to the 10th Circuit, which is the appellate court in the federal system for the state of New Mexico. So if you're in a federal court, trial court in New Mexico, and you lose and you want the decision overturned, you would apply to the 10th Circuit Court of Appeals in the federal system. Now, what will the federal court of appeals, the 10th Circuit, what will they do? They will do the same thing that the trial court in New Mexico Federal Court number 2 did, which is they will defer to the New Mexico Supreme Court's decision on state law, and they will uphold and respect that decision, and they will hold that the agreement browse rep agreements, at least as they apply to Mexico, are not binding, and they will reverse the decision of Federal District Court number 1. So, as far as any state or federal court in New Mexico goes, since the New Mexico Supreme Court has spoken on the issue, browse rep agreements are not binding in that state. Now I'm at the bottom of page 12, or I'm sorry, 13 of the handout. And now we're in another state, the great state of California. And the issue comes up regarding browse rep agreements in California and whether they're binding. And the question or the issue to be asked is, are any of these decisions in New Mexico State Court or the New Mexico Federal Court, particularly the 10th Circuit's decision deferring to the state of New Mexico, does California have to follow these? Are they bound by the doctrines of precedent and stare decisis to agree with the New Mexico Supreme Court and the 10th Circuit Court of Appeals in the federal system? The answer is no, because this in California is a case of first impression. They are not required to follow the New Mexico Supreme Court because the contract law in California might be different than New Mexico, and they're not in the same system. California's got its own court system. They're not bound by what the courts of New Mexico does. Are they bound by the decision of the 10th Circuit Court of Appeals? The answer is no, again, for two reasons. One, the 10th Circuit Court of Appeals decided the case under New Mexico state law. Remember, the holding in the 10th Circuit is New Mexico Supreme Court has spoken on the issue. They're the experts on New Mexico state law, and we're going to defer to their interpretation of contract law in New Mexico. The other reason, although this isn't central, but I need to explain it to you, is the California federal courts are not bound by decisions from the 10th Circuit Court of Appeals. Why? Because the California federal system, the Court of Appeals is the 9th Circuit in San Francisco. So a federal district court, which is a trial court in California, is not bound by a decision of the 10th Circuit. If it was the 9th Circuit, absolutely they would be bound, but it's the 10th, so they're not in the direct chain of command. Now, would we want to bring up the 10th Circuit's decision and the state of New Mexico's Supreme Court's decision in the California federal court? Well, if it helped our client, you bet we would want to bring up those cases. If we wanted to, we represent our client where it helped our client with the decision that browse rep agreements are not binding, definitely we would bring them up. But we would call those persuasive authority. Those are decisions that we would tell the judge in the federal trial court here in California, hey, look what New Mexico State Court did, and look what the 10th Circuit federal court did. The reasoning in those cases was really, really good. And so in California, you should hold that the agreement is not binding. But is the judge compelled or forced to follow those decisions? The answer is no. Now, if I represented my client would be benefited by the California federal trial court holding that it was binding, I would try to distinguish those cases in New Mexico and the 10th Circuit. I would say, well, California law is different, even if the reasoning in those cases was flawed, whatever it might be. But I would do everything I could to convince the federal trial court in California that those judges in the 10th Circuit and on the Supreme Court of New Mexico are idiots. Well, I wouldn't say it in those words, but that would be the point. Now, at the bottom of page 14, the California Federal District Court decides to side with the 10th Circuit and the New Mexico State Supreme Court, and they hold that the browse record agreements are not binding. The loser in California federal court decided that they wanted to appeal, and so the appeal would be taken up by the Ninth Circuit Court of Appeals, which is in San Francisco, and the issue becomes, are any of these decisions binding on the Ninth Circuit? The answer is absolutely not, okay, for the reasons I explained earlier. One, the 10th Circuit Court of Appeals is on the same level as the Ninth Circuit, so they're free to make their own decision. They don't have to follow the decision of somebody on the same level as them. They're free to reach their own agreement, or their own decision. So, for whatever reasons, the Ninth Circuit Court of Appeals in San Francisco reverses the trial court in California federal court and ends up holding that the agreement is binding. They are not bound by any of the other decisions for the reasons that I have discussed. Now, why are they not bound? Other than, remember, they're on the same level as the 10th Circuit, and New Mexico State Court doesn't have any binding authority on the federal Ninth Circuit. The other reason is California, we don't have any facts that California state courts have decided this issue. If the California Supreme Court had held one way or the other, the Ninth Circuit would then defer to the California Supreme Court's decision on California state law. Since they do not, there's no case that has decided that, they're free to decide it on their own. And so now we've got a Ninth Circuit Court of Appeals holding that is binding, and the 10th Circuit Court of Appeals holding that is not binding. I hope that this handout in this lecture was helpful to you in trying to figure out whether a case is what we would call controlling authority on a particular court. If it wasn't helpful, just email me and we can talk individually. You know, we can Skype on it or FaceTime or just talk on the phone. So don't hesitate to call me if you're still unclear on these concepts. That's what I am here for.